Hello, this is Scott Horton. I will be presenting today's webinar on New York employment law updates. We will get started in a few minutes because we've just opened this live to attendees, and everyone will be signing in the next couple of minutes, and then we will get started. I'll keep popping in periodically to say hello just to make sure that everyone can hear me. Otherwise, as you're joining, you should be able to see a cover slide for the presentation today, and you should have access to a chat window where you'll be able to ask questions during the presentation. I'll go over all the logistics again as we get started formally, but I do welcome you and thank you for attending. As you join, you should be able to hear me and see the cover slide for the presentation 2023 New York Employment Law Update. Make sure you can also access the chat window where you will be able to enter questions if you have them. And we will get started in just a couple of moments. We have a large number of registrants today, so just need to give everyone a chance to get logged in. And hopefully once our scheduled start time hits, we will be able to get moving with the presentation, which is expected to last approximately 1 hour, and I will do question and answer at the end. I normally stay on to answer all the questions that come in, even if that takes us past the hour. But if you have a question, I encourage you to ask it when you have it so you don't forget. Just give me another moment or two and I will come back on and we will get started. Hi again, I am Scott Horton. I will be today's presenter on the 2023 New York Employment Law Update from Horton Law PLLC. I am based in the Orchard Park, New York area, just outside of Buffalo, and represent clients throughout the state of New York. Today's presentation is going to cover various topics of recent developments within New York State specifically, and a few developments at the federal level, which will impact New York workplaces as well. As I mentioned a few moments ago, if you have questions, enter them in the chat function of the webinar software. And if I happen to see a question and there's a good opportunity to answer the question, I will do so. I do see a question about sound. Hopefully everyone can hear me. If someone can just confirm that they do have sound, that would be great. If you are having any technical problems, you may want to log out and log back in or close other applications on your device. Okay, so again, I will answer questions at the end. At the end of the presentation, I will also be providing a link to these slides. And if you are registered for the program and watching on the account that you're registered for, then you will get an email tomorrow with a link to the materials as well. And again, we are aiming for about an hour today, and I will stay on at the end to answer as many questions as come in. With that, let's get started. And I want to begin at sort of a basic component of New York employment law, and that is the current minimum wage. There are some special minimum wages in the fast food industry and in the hospitality industry. There are tipped wages. If you're in those affected categories, then you hopefully are familiar with the latest requirements in those areas. But generally speaking, throughout the state of New York, we have only two hourly minimum wages right now. The minimum wage for New York City, Long Island, and Westchester County has hit $15 per hour. The New York State minimum wage for the rest of the state, which is the overwhelming majority of the land area and counties, pretty much everything outside of New York City and Long Island and Westchester, is $14.20. That rate is anticipated to go to $15, and it is fairly likely that it will get to at least $15 at the end of 2023. There is a lot of discussion now and legislation proposed in Albany to tie minimum wage to cost of living increases on an annual basis. There are separate and in some cases connected and related discussions about increasing the minimum wage to $20 or thereabout relatively soon. So at this point, that is all up in the air, but I would anticipate the minimum wage for most of the state will increase at the end of the year if there's not some further increase implemented out of Albany sooner. Along with the regular minimum wage increase, the exemption threshold for upstate New York increased at the very end of 2022. So that is now $1,064.25 per week for the administrative and executive exemptions. A couple of the exemptions in New York, like the professional exemption and the outside sales exemption, don't have salary requirements, although the professional exemption does have a requirement for salary under federal law. So be careful if you're in those categories, but otherwise, generally, the New York state salary requirement is higher than the FLSA federal requirement. The exemption threshold is leveled off in New York City, Long Island, and Westchester at $1,125 per week. Again, it is likely if there are further increases in the New York minimum hourly wage that the exemption threshold would correspondingly increase. While we're on the topic of wages, some of you have employees in New York City and are already subject to the New York City pay transparency requirements that went into effect in November of 2022. Since then, New York has adopted similar requirements at the state level. However, those have not yet taken effect. They are set to become operative September 17th, 2023. As of that date, employers with 4 or more employees who are hiring someone in New York would be subject to the new statewide pay transparency law. This relates to advertising job positions and has some requirement that certain information be included in those job postings, which I'll get to in just a moment. I will note that I personally read the law as written to leave some ambiguity whether the public sector, that is governmental entities, are covered by this requirement. There are basically 2 different definitions of employer in one public entities are specifically excluded. In the other, they're not directly addressed, so there is some ambiguity there, and I've not yet seen definitive clarification. So if you are in the public sector, I'm honestly not 100% sure yet whether this law will apply to you. On many of these issues, we do anticipate the New York State Department of Labor will issue regulations, rules, and/or guidelines before September 17th, 2023. Ideally, I would like to say that we might see those before September, but I really don't know. Sometimes they are relatively last minute on these types of things, but they do still have a number of months here to hopefully get some guidance out. If you are subject to this new statewide law, then your job postings, if you choose to post open positions, must include compensation ranges, and if you have a job description for that position, the job description as well. There is an exclusion for temporary help firms, so staffing companies that are hiring a pool of individuals to place at various companies where they presumably will have varying compensation structures. There is a carve out in the law for that scenario. So let's get a little bit more granular in what the law requires as far as we can tell so far. You need to provide a minimum and maximum annual salary or hourly range of compensation, depending on which applies. There currently is not much guidance on what that range should look like. The law says that it needs to be based on the employer's good faith belief at the time of posting for the position. The only further clarification in the law that is if the job pays solely on a commission basis, then employers only need to provide an indication that compensation is based on commission. We again anticipate the Department of Labor will be at least encouraged to provide some guidance on what might be an appropriate way of determining a compensation range, but there is no certainty that they will do so, and exactly how big a range would be deemed acceptable is currently anyone's guess. So again, this is going to be relevant when you are posting for positions in New York. There is some clarification on what that means in the law, which actually was already amended after being initially passed at the end of 2022. You need to include this information, both the compensation range and the job description, if you are making available to a pool of potential applicants for internal or public viewing, including electronically, a written description of an employment opportunity. I think they probably could have written that in English if they had sought to do so, but unlike most normal people, people who write laws tend to write things in very convoluted ways for whatever reason. The key point here is you're not required to post every job that you have available, but if you do post it and you're large enough to be covered by the statute, which is going to be most employers in New York State, then you would need to include the compensation range, and if there is a position description for that job, the position description as well. It is possible that the Department of Labor will clarify that job description requirement in some respects, including do you have to post an entire job description in all situations where the space may not be conducive. If you were, for example, posting a traditional want ad in a newspaper, it would be difficult to include an entire job description, or at least very costly. I suppose that's one way to help support the print media industry, but it is conceivable, for example, that they may say that it would be sufficient to indicate an email address where you could contact someone to get the job description, or perhaps a link to it on a website somewhere. But that is uncertain at this point. The requirements do apply not only to hiring outside individuals to new positions, but also postings, even if they're only internal, for promotions. So keep that in mind as well. If, for example, you put something up on a bulletin board, be it physical or electronic, within your organization, that would still count as a job posting, and hence you would need to include the compensation range and, if applicable, the job description. The other clarification is that the job is supposed to be physically performed, at least in part, in New York State, or, as amended, the law says that it applies to positions even that are performed outside of New York, but report to a supervisor office or other work site in New York. Not entirely sure how far that's expected to extend, but I suppose in the era of increased remote work, that any New York company that is applying for a job that's not going to be physically performed in another state, or could potentially not be performed physically at a job site in another state, should be considering complying with these new requirements, again, when they take effect in September. Okay, let's move on to another issue that is sort of a hot topic currently in a few places. For our purposes, most specifically in New York City. This relates to something that the New York City folks are calling automated employment decision tools. There's a definition here of what an automated employment decision tool means, and among the components are artificial intelligence. It doesn't necessarily have to be an artificial intelligence based system, but it's some form of machine computer computation algorithm that somehow spits out a mechanism of either ranking candidates or selecting candidates for a position, or not limited only to hiring decisions or promotion decisions, but also could relate to other employment decisions, potentially including discipline, for example. This law is in effect now in New York City, technically, but enforcement has been delayed currently until April 15th, which is very soon if you're watching this live. So as of April 15th, employers should not be using these automated employment decision tools unless there are parameters in place that if an employer can satisfy them, they would be able to use these mechanisms. In that case, an employer has to be able to show both that the particular tool used has been subject to a bias audit in the past year. This bias audit would be to determine whether the mechanism has some sort of disparate impact on individuals based on race, gender, or national origin. Most particularly, technically, there are already laws that would potentially give someone a claim if they were denied employment opportunities or otherwise subjected to negative employment decisions based on any mechanism, whether computer generated or human based. But this is a more specific law, an additional law based specifically on these computerized tools. Beyond that, once the biased audit has been conducted, the employer has to post a summary of the results of the most recent biased audit on its website before using the tool to make employment decisions. Now, there are likely some forms of software and other such tools out there that have been already subjected to a bias audit, whether in anticipation of these New York City rules or otherwise. However, certainly there are a number of tools, especially relatively unsophisticated programs that individual companies may have come up with on their own that they may not even really be thinking of as qualifying for these AEDT restrictions. But if they are computer-based, they may be subject to these requirements, and therefore the employer would need to go out and arrange for some sort of bias audit. Problem being how easy it's going to be to get such an audit conducted, especially if the tool has never actually been used before. So there are a lot of open questions on how this is all going to work, assuming it actually does start to be enforced in April. But employers are certainly cautioned against using computers to make employment decisions without considering these restrictions, at least in New York City currently. But as many other things have been doing recently, the New York City restrictions could sooner rather than later lead to statewide restrictions. There are other notice requirements that apply when you are going to try to lawfully use these in New York City, including you have to disclose to the individuals subject to these AEDTs, in other words, applicants or employees, depending on the circumstances, what job qualifications and characteristics will be considered in the programming of the tool. In other words, presumably you need to identify that this is going to be based on an evaluation of work experience, education, testing, whatever it is. And that, of course, is not something that every employer would want to identify so publicly, but that is a requirement of the law to use these tools after the law becomes enforceable. Stepping broadly back to the New York State level, there is one relatively recent amendment to the New York Human Rights Law, which is the statewide anti-discrimination law. Among the various protected categories, the law now includes citizenship or immigration status. It's quite possible that individuals who may now make a claim based on citizenship or immigration status would have previously had a claim based on some other status, such as race, for example, or national origin. But now, if an employer makes an adverse employment decision, or for example, there's harassment based on someone's citizenship or immigration status in any way, shape, or form, that could lead to a claim of discrimination in violation of the human rights law. If nothing else, this means that you should review your policies and probably add this category if your policies currently aim to include a fairly comprehensive list of the numerous categories protected under New York law. Further related to the New York human rights law, the sexual harassment area has had a couple of recent developments. Last year, the state implemented a hotline that employees or former employees should be able to call. The intention is to then connect those individuals with attorneys who have experience representing employees in sexual harassment cases. The hotline number is 1-800-HARASS-3. I'm not sure why exactly they chose that number, but that is what the state came up with. So that is the number. This should be reflected in your New York State compliant sexual harassment prevention policies, where you're generally required to include information about where employees can go if they feel they have been harassed. I have some questions over how effective this hotline is going to be, because the state needs to get attorneys who are willing to take these calls, subject to the requirement that the attorneys can then not become paid representatives of the employees they speak with through the hotline. So I'm not sure how much motivation the attorneys experienced in sexual harassment cases are going to feel that this is going to help them, and why they would do much more than just refer someone back to the Division of Human Rights, which is who is going to answer the calls on the hotline in the first place. But in any event, again, I think you should have that in your policy, keeping in mind that very recently the state has also put out a proposed new model sexual harassment policy. Doesn't necessarily mean that if adopted as the state's model policy, every employer will have to adopt it, but it does raise the question of whether you would at least need to modify your current policy to include any of the new aspects of the state's model policy. So what types of things does the model policy now look for or include? It says specifically that sexual harassment need not be severe or pervasive to be illegal in New York, and it specifically says that intent is irrelevant. Now, generally speaking, those are legally accurate statements. However, before now, there hasn't been any suggestion that employers need to specifically spell that out for their employees. I personally question the full scope of the phrase that the intent is irrelevant, because I think realistically, if you went through litigation and you got at least to the damages consideration, that the intent may indeed have some relevance, but the clear point is that there's a relatively low standard for a claim of sexual harassment in the workplace in New York, and the state is trying to point that out to employees more than it had before. Another area that has received a lot of attention from the state relates to gender and gender identity types of issues. So the new model policy does significantly expand on its attention given to the issues of gender, gender identity, gender expression, and sexual orientation, including examples that treating someone differently than their preferred gender identity, or using incorrect pronouns based on someone's preferred gender identity, and pronoun selection could in and of itself constitute sexual harassment. The model policy has a specific list of 5 bystander intervention methods. These are steps that individuals who witness perceived sexual harassment in the workplace can take to help prevent it from occurring again, or remedying the harassment. That is a new expansion, at least, on the idea of bystander intervention. There is a new, not entirely surprising, clarification that sexual harassment can happen in a remote workplace. And that's probably always been legally true. But of course, in the last couple of years, remote work has become so much more common that it makes sense that they would have thought to address that now. And at the very end of the new model policy, there is language that, in my characterization here, frankly, attempts to expand the policy to harassment based on other protected characteristics. It literally says something to the effect that while the above is a sexual harassment policy, there are many other protected characteristics in New York, such as, then lists them, and says that this policy should be construed to apply to harassment based on any of those characteristics as well. Now, I do think that employers should have policies that address all of those other categories, but I'm not a big fan of the way the state is trying to just incorporate them by generic reference into the sexual harassment policy. And I'm not really sure that the state would have the legal right through a model policy to require employers to implement harassment policies based on the other protected characteristics, where the law itself only specifically requires a sexual harassment prevention policy. So again, there was an opportunity to provide comments on the proposed policy. That period is technically closed, I believe, but there's not been any further publication of what the state is going to do with the policy going forward. But this is an area that you should continue to watch, and it will be important to determine whether the state's position is that all the new changes need to be reflected in every employer's policy, or they're just putting it in the model policy so that it will at least be adopted by those employers that come along and are interested in using the state's models. While we're on the topic of discrimination, there was an amendment to the New York labor law that now expressly prohibits adverse employment action based on an employee's use of any legally protected absence pursuant to federal, local, or state law. We'll get back to what such protected absences may include, but the law goes on to now say that prohibited conduct includes assessing any demerit occurrence, any other point or deductions from an allotted bank of time, which subjects or could subject an employee to disciplinary action, which may include but not be limited to failure to receive a promotion or loss of pay. Again, I think they could have worded this much differently, but that's not all that surprising. We have to do our best to understand what all of this means. What pretty much everyone understands this amendment to mean is that the state doesn't like no-fault attendance policies and is trying to at least clarify existing discrimination and retaliation protections and make it clear to employers that you can't try to hide behind no-fault attendance policies to effectively discriminate against employees taking time off that they're legally allowed to take off. So I just want to identify what some of the types of leaves that are likely covered by the law include: the New York paid sick leave, New York paid family leave, New York paid COVID-19 leave, the vaccination for COVID-19 leave, which is still in effect at least through the end of this year, the actual COVID 19 sick leave law that took effect back in March of 2020 is still on the books with no expiration date. So you still may be entitled or obligated to allow employees to be out of work potentially for up to 10 days if they test positive for COVID-19, and potentially up to 3 times. At the federal level, there's the FMLA, which is certainly a protected leave. There are other specific New York leave laws in place, blood donation leave, for example. In certain cases, there might be voting leave, and a few other categories that don't come up as often and generally don't involve extended periods of leave. There is also a leave that's offered as an accommodation under the Americans with Disabilities Act or the New York Human Rights Law. I think probably the law intends to include such leave. If we go back quickly and look, it says any legally protected absence pursuant to federal, local, or state law. There is a question whether that means a leave that's specifically provided that someone has the right to take under law, or do we go by extension? The ADA and New York human rights law certainly permit leave as an accommodation, but don't necessarily require it under specific circumstances. But let's assume that's probably covered. Then I asked a question of what other forms of protected leave may apply. There are some questions, for example, about what happens if an employee is out of work receiving workers' compensation benefits or short-term disability benefits as required by state law. Those laws as written are not specifically leave laws. They are benefit laws and don't necessarily entitle someone directly to remain employed. In those cases, traditionally, the continued employment while out receiving those benefits has technically been likely an accommodation, such as under the ADA or the human rights law, or pursuant to some other company policy. And then there are other leaves, such as personal leave and vacation or paid time off, that employees are given that may still be separate and apart from the New York paid sick leave entitlements. Now, technically, the law doesn't require any employer to provide those types of personal leave or vacation time. But first of all, if you have a PTO bank that includes sick leave, that might raise a question of whether your entire paid time off bank is subject to this protection. And then at the other end of the spectrum is, even if you just have a pure vacation leave policy, there is language in New York state law that talks about essentially that you don't have to offer vacation, but once you do, you have to put it in writing. Is that enough of a legal connection that it would now be covered by this specific anti-discrimination protection? I don't think there's any way to know for sure the answer to that question until there's either some further guidance from the state or it is challenged in some fashion. For the most part, then, I think that this law doesn't change very much. I mean, you already couldn't retaliate against someone for using sick leave, paid family leave, or family medical leave. However, again, at the margins, there are some types of leave for which an employer, at least previously, would have probably felt comfortable saying, look, one way or the other, you're taking off too much time, and we don't think that you should be able to continue working for us. It's pretty clear the policy implication is that if employees can find a reason to be off of work, then it should be difficult to end their employment unless they're just purely doing it, for no good reason. So we'll see how far this goes. Not entirely game changing, but certainly gives employees another statute to point to if they feel like they have been wrongly targeted with some form of adverse employment action, which could include discipline up to termination. Then they do have the opportunity to make this claim under New York statutory law, separate and apart from these various other provisions that may already provide some protections. Okay, among those leaves, I mentioned New York paid family leave. There are some new developments in that area effective in 2023. Primarily, the law was amended to add siblings as covered family members. So specifically for an employee who is taking paid family leave to care for a family member and their medical condition. Previously, that included children, spouses, parents, grandparents, grandchildren, and now includes siblings without much limitation. Not only is it open-ended as toward biological siblings of any age, it also includes step and half siblings, which I suppose in some cases could create some questions as to what qualifies as a step or half sibling, and potentially there's further documentation that would be questioned on that. But getting beyond that, you will see I've cut off a portion of new forms that the state has put out that shows at the bottom the sibling box added. Another box has been added is towards the top of this graphic where it says employee's gender. Instead of just male and female, there is now a box for X, and the forms have otherwise been written to eliminate gender-specific pronouns. So as I mentioned before, there's continued focus on the gender identity and expression issues, and that is now reflected in these forms, at least from New York, and certainly would anticipate that as other forms need to be created and developed or updated, that we might see similar revisions. Also on paid family leave, every year there are some numbers that change, specifically the rate of benefit that employees are entitled to and the rate of contribution that employees need to make into the system, which is basically intended as an employee paid insurance system. The requirements of paid family leave benefits phased in over a few years. They've now been fully phased in, so employees can get up to 67% of their average weekly wage for up to 12 weeks per year, but that rate is capped at 67% of the New York State average weekly wage. For 2023, that average weekly wage is $1,688.19. Meaning that the maximum weekly benefit is $1,131.08. So an employee who, once you take 2/3 of their regular average weekly wage, it would be higher than that $1,131 number, will still only get that much money. The good news for employees is the maximum weekly benefit has continued to rise over the years. It has basically doubled since paid family leave first took effect in 2018. A lot of that doubling is not due to the average weekly wage doubling as much as it is to the fact that the number wasn't 67% in the first couple of years. But even in the last couple of years where we are at the 67%, you're still seeing close to $100 increase in the maximum weekly benefit. But again, there's really no way to predict that number year to year. It is set by the state based on its calculation of an average weekly wage. So I'd anticipate it to continue to rise for various reasons. The exact amount by which it would rise is not guaranteed, and it is at least theoretically possible the number could go down at some point. On the flip side, as I mentioned, the employees are obligated to contribute and effectively pay for the insurance that employers have to provide for paid family leave. Employers are not obligated to collect the money from their employees, but the intention is that they're going to, one way or the other. The state basically sets the cost of this insurance, so insurance companies don't have any control over these rates. It is fixed by the state, and if insurance companies want to offer this insurance, then they have to charge these rates. Because of that, the rate is changed every year with the intention that the state should be making it viable for insurance companies to provide this insurance. For 2023, employees can contribute 0.455% of their gross wages per pay period, up to a maximum annual contribution of essentially $400, $399.43. The good news again for employees is that for the first time this year, the contribution rate has actually gone down. So it was very low at first, again, because the benefits were lower and did not reach a full 12 weeks, for example. They then increased considerably as the benefits increased based on the designed expansion of what the law allows. For whatever reason, the last 2 years, the number was exactly 0.51%. There was really, however, a specific surcharge related to COVID being added in there of about 0.05%, I think. So the 0.46% number this year is really intended to be about the same as the last 2 years minus the COVID factor. And in real dollar numbers, the maximum annual contribution has also decreased this year. So last year, employees could have paid up to $423.71. So on an annual basis, that is about a $25 savings to employees who are at the maximum contribution level. Again, really hard to guess which direction this number is going to go, other than at least hopefully we are beyond a lot of the COVID impact. But we will have to see where it is. Obviously, $400 is a lot more than the $85 that employees were paying in the first year. So it is real money coming out of employee paychecks, again, assuming the employer is making that deduction. All right, now we have just a few more laws that I wanted to run through. A few of them are going to relate to this issue of pregnancy and nursing. And it gets a little confusing here because we have both state and federal laws that are coming online around the same time. And these laws, in some respects, are amendments or related to laws that are already in place. The New York Nursing Mothers in the Workplace Act is going to take effect June 7th, 2023. Technically, there's already this law in place, but there are some new amendments. The amendments are going to provide more specific requirements on what nursing mothers are entitled to. Basically, the law already requires employers to provide a space for nursing mothers to express breast milk for up to 3 years after birth. But now there's a lot of more guidance on what the room needs to feature. If at all possible, basically, should be in close proximity to the specific employee's work area, well lit, shielded from view, free from intrusion by other people. The law says specifically that there should be a chair and a working surface and nearby access to clean running water. I think that wording is intended to mean you don't actually have to have a sink in that room, but it should be close to a bathroom, for example, or somewhere else where there's running water, and an electrical outlet, which presumably is there to address the fact that there are electric pumps that may be in use. The law also refers to access to refrigeration. If there is refrigeration possible in the workplace, obviously there are some exceptions here for jobs that are entirely off-site and especially outside. And basically, once stating all these new requirements, there is a limited exemption in the case of undue hardship, similar to what employers would be familiar with in the accommodation realm. So if based on cost and circumstances, number of employees, size of the business, etc., meeting all of these requirements is an undue hardship, then basically the employer is expected to do the best it can and meet all of the requirements that it can possibly meet. The law does something that's relatively unusual and maybe even unique. It requires a written policy and appears to specifically require a policy that will be written by the Department of Labor. So the Department of Labor, before June 7th, hopefully, will need to issue a policy on these requirements. And then the way the law reads, it appears that employers must adopt that specific policy. There does not seem to be any suggestion that employers have the opportunity to deviate and adopt their own policy. All right, so now we go to the federal level on basically the same topic. There's something called the Providing Urgent Maternal Protections for Nursing Mothers Act, or PUMP Act. This affects the Fair Labor Standards Act, which again has pre-existing requirements related to giving nursing mothers the opportunity to express milk during breaks to express milk during work. There's clarification. This applies to both exempt and non-exempt employees. This expansion takes effect June 27th of this year, but frankly, the New York law already goes further. So there's not too much of an impact in New York specifically for employers already subject to the New York law, but something to be aware of if you hear about it, and to know that you're not able to just comply with the federal law. You have to also comply with the New York law, assuming your employee in question is in New York. Sorry, the last bullet on here is a carryover. This federal law takes effect June 27th. The other date is incorrect. Nope, sorry, got that backwards. I'll clarify that in a moment, because I didn't mean to have two dates on this slide. Again, all these pregnancy laws and nursing laws start to run together. Pregnant Workers Fairness Act is another federal law. Yeah, so this PUMP Act took effect December 29th, but again, the state laws basically already cover this. The June 27th language was really meant for this Pregnant Workers Fairness Act. So this requires reasonable accommodations to known limitations related to pregnancy, childbirth, or related medical conditions. To the extent that any of these conditions qualified as a disability, then the ADA would already have required reasonable accommodations, but some of these circumstances would not qualify as a disability. So now at the federal level, beginning June 27th, there will be an affirmative obligation to accommodate employees, and clarification that the employer can't require leave if another reasonable accommodation is available. So while leave is generally considered a form of reasonable accommodation. And in the disability area, employers generally have the right to determine which accommodation they're going to offer. This law is specific to say if there's some other accommodation that could be made, the employer can't just say, we'll just take time off, whether paid or unpaid. And again, the clarification I meant to say is that these accommodation requirements are already in place under both the New York City law for employees working there and the New York State law. Those two laws have slightly different wording and slightly different requirements. But again, this is a federal law that will apply throughout the country and doesn't have as much impact in New York. Couple other odds and ends here as we wrap up. I know there's some good questions coming in, and I'm going to answer those and address those topics in the Q&A. The electronic posting requirement took effect in December, so this was pretty surprising. All of a sudden, the state said, oh, by the way, all those workplace posters and any other documents required to be physically posted at a work site must also be made electronically available to employees, either through the employer's website or by email. It took effect immediately, not really giving anybody a chance to figure out how they were going to fully comply with this. And there's still ambiguities as to what this includes. Presumably includes the standard employee rights notices that get posted on bulletin boards, but it does say any other documents required to be physically posted at a work site. So in specific cases, if you're required to post something as a result of a compliance finding or something like that from an administrative agency, then arguably that needs to be made available to employees electronically as well, even if the particular administrative agency didn't specify that as a term. The law also specifically requires employers to notify employees that such documents are available electronically. I assume that if you are emailing all these documents to all of your employees, that simultaneously qualifies as notice, but the real impact of that separate provision would be to say if you are just posting these on your website, you can't just hide it somewhere on your website. You have to actually let employees know that these postings are on the website. So it seems like in most cases you're sending an email one way or the other. I guess if employees don't have email and you're just posting on your website, you still have to find some other way to notify everyone that the documents are available electronically. This is a pretty limited Warehouse Worker Protection Act, but if you are in the business of operating warehouses, there are specific NAICS codes that determine which businesses apply, but a lot of wholesalers are going to be subject to this. You either have to have a warehouse with 100 or more employees, or a combination of warehouses in the state with a total of 1,000 or more employees. Basically what this says is that employers can't impose quotas that will interfere with the employee's abilities to take reasonable meal and rest and bathroom breaks. And then even if you have quotas that don't do that, you are limited in certain ways in how you use those quotas. Most notably, if an employee is disciplined, they have the right to get quota data not only for themselves, but also for other similar employees, so they can compare whether and how the quota was applied against them versus others. Generally speaking, the law also requires that employers who are imposing quotas give each affected employee a written description of the quotas that they are subject to. This law technically took effect briefly and then was amended, and as a result of the amendment, does not actually take effect again until June 19th, 2023. But if you have warehouses, make sure you monitor what this means for your workplace. The HERO Act was a COVID byproduct. It didn't actually limit itself or specifically address COVID, but it did create this requirement that employers have standing airborne infectious disease exposure prevention plans. That remains in effect indefinitely. There's no intent for that to sunset. The idea is you have to have a plan so you can implement it quickly if there is a declaration by the state that a disease is highly contagious. So right now, COVID is not so designated. It had been previously, and there's nothing else that is so designated, but you still have to have such a plan and post it in your workplace and be prepared to implement it in case there is an appropriate declaration. The other part of the HERO Act, you may remember, related to the creation of workplace safety committees. Again, this wasn't in any way limited to COVID and wasn't in any way limited to the Airborne Infectious Disease Exposure Prevention Plan. It's much broader. The only change here is that in December, the law was amended to now require employers to recognize workplace safety committees within 5 days of creation. Honestly, no one knows what that means. That, you know, who creates the workplace safety committee is still somewhat up in the air, and the regulations that the Department of Labor had originally put out regarding workplace safety committees, I believe, have expired without formally being adopted. Not many of these workplace safety committees have actually been created, but the bottom line is if employees are trying to create a workplace safety committee, you better act fast in figuring out what you need to do. Potential penalties include $50 per day in fines, but are not limited to that. And nobody knows what else they might include. But the obvious gist of this is the state wants employers to be prepared to act on this quickly when employees invoke this right. Perhaps most recently at the state level, the New York State WARN Act has been a topic addressed by the governor. There is an announcement that there's a new online notice portal expected in April. This is a means where employers who are subject to the WARN Act, who are laying off employees in large enough numbers, at least 25, depending on the circumstances, currently have to provide notice to various governmental entities, including the State Department of Labor. The idea is this new portal is going to expedite that process, make it easier for the state to respond quickly once they receive this information. There are also new proposed regulations from the Department of Labor. I put some of what I think are the most notable expansions of those regulations on here. That you have to now provide the New York State Department of Labor personal contact information and pay status information, like whether they're full or part-time or paid hourly or salary for each individual affected employee. You have to give employees additional information regarding severance and dislocated worker assistance, among other things. And you have to make basically an application to the Department of Labor to be able to apply any of the exceptions that might be available to satisfying the full 90-day notice requirement under the WARN Act. I think some of these issues may be beyond the scope of the statutory authority that the Department of Labor has, but they have proposed these requirements in regulations that are currently not adopted and are subject to a comment period, after which we will see what the Department of Labor does. But in the event that you are laying off large numbers of employees, don't forget to comply with the WARN Act generally and make sure you look into these new circumstances that you may need to comply with. Finally, the latest development at the federal level, and then we'll get into questions, relates to severance agreements, which I just brought up in the context of the WARN requirements. WARN doesn't require that employees receive severance offers, but whether in that scenario or in any other scenario where an employer is trying to provide an employee some form of severance conditioned on usually waiving certain rights, the National Labor Relations Board at the federal level, which only affects private employers, but does affect private employers in New York State in most instances, has issued a recent decision in a case called McLaren-Macomb that says that just offering a severance agreement to an employee that contains a broad confidentiality and or non-disparagement provision is an unfair labor practice, meaning a violation of the National Labor Relations Act that could subject the employer to penalties. And that's even if the employee doesn't accept the severance offer and never signs the agreement. I'm not going to go into that in too much more detail other than to say that after that decision, the general counsel of the National Labor Relations Board, who's essentially the ultimate prosecutor of National Labor Relations Act violations, issued a memo suggesting that basically any type of confidentiality or non-disparagement provision is likely, in her mind, to be a violation of the National Labor Relations Act, and that it could be applied retroactively, such that she goes so far as to suggest that employers reach out to any employees or past employees who are currently subject to severance agreements that have confidentiality or non-disparagement provisions, and letting them know that the company has no intention of enforcing those provisions. And that by way of saying that if you don't do that, then the NLRB might come along and find you in violation of the National Labor Relations Act, basically regardless of how long ago that severance agreement was entered into. These are pretty drastic and highly questionable positions from the National Labor Relations Board. But if you do have issues and questions about how to deal with this new guidance, you should certainly discuss it with an experienced labor attorney. With that, I'm going to go to questions. Just want to provide the link for our LinkedIn page, which is where we normally post our most up-to-date labor and employment law updates. So if you don't already follow Horton Law on LinkedIn, you may want to do that. And then if you have other specific questions, you can contact me at this information available. Otherwise, I'm now going to go into the Q&A. But before I do that, let me throw up the link to the slides, because I know some people may not be able to stay on much longer. All right, so you should be getting on your screen a link to download the slides if you want to get those. But again, you will get an email tomorrow with the link as well if you don't feel that you need them immediately. Now let me check on questions. If you still have questions, you can keep entering them. I'm not going to cut that off until after I answer all the questions that are already in the queue. If you have questions that are going to disclose any confidential information or information that you don't want discussed potentially among others, then you might want to ask me those questions offline. But barring that, and assuming your questions of a general nature, happy to try to answer it here. Will the New York State COVID-19 leave law be sunsetting soon? There is recent effort by the New York State Business Council, it's effectively a chamber of commerce for employers in the state, that is trying to get the law repealed. However, there is no termination or sunset date in the COVID leave law itself. So unless the legislature actually repeals the law by affirmative vote, then it's going to stay in effect indefinitely. The last guidance that I've seen from the Department of Labor is still from a couple of years ago, where they said that any individual can only have up to 3 leaves under that law, presumably meaning over whatever time period, and that the second and third leaves have to be based on a positive test. So if you have employees who've already taken their 3 leaves, then they may be done, but otherwise the law itself remains on the books indefinitely. The vaccine leave law is one that was limited in duration, but has now been extended through the end of 2023. So if you still have employees who want to take time off from work to get their COVID vaccination, they still have the right to do that. Here's a question that says, if I have a termination scheduled for Friday, the person finds out and gives notice that they want to take a leave in effort to protect their job, do they have to remain employed? No, that's not what that leave discrimination law clarification is intended to address. You can still take adverse employment action for any lawful reason. What the law is now saying is that it really targets no-fault attendance policies, which historically were policies that said, okay, if you miss a day of work, you get a point. If you get to 7 points or 10 points or 80 points or whatever it is, then you get terminated. Maybe there's other forms of discipline along the way based on different numbers of points. And the idea there was, we don't care whether you're sick or whatever, goofing off or taking vacation. If you do it too much during a specific time period, then you are going to no longer work here, because we need employees who are going to actually show up. Over the years, as the employment laws developed and gave more leave rights, primarily including the FMLA, it was clear that you couldn't count an FMLA absence in a no-fault attendance policy. So again, like I said, some of those protections were already really in place. I think it would have been suspect to use a no-fault attendance policy to count an absence that was somebody's accommodation under the ADA or human rights law, for example. And then as we see these newer laws, paid family leave, New York sick leave, the COVID vaccine leave, these laws all specifically prohibit retaliation for taking these leaves. So again, I think it's pretty clear they couldn't be used in these situations. So again, as long as you have some other non-discriminatory reason for terminating or otherwise disciplining an employee, the fact that they want to take leave doesn't matter. Just like you can currently fire someone who's out on Family Medical Leave Act, you just can't do it because they're out on Family Medical Leave. And if you do fire someone who's out on FMLA leave, then you better be prepared to prove that it wasn't the FMLA leave that motivated the firing. Can you charge all employees for paid family leave insurance, or is there an age requirement? And there's no age requirement. The default is that all employees in the private sector have to be covered by paid family leave with limited exceptions. Once you have an employee and they're eligible to be covered by paid family leave, you should be able to charge them for their contribution. There may be 2 exceptions worth mentioning. One is if you're in the union context, it might be something that is negotiable, and theoretically you could have negotiated something different with the union. The other exception is in limited scenarios, employees can waive coverage of paid family leave. And the only real reason why someone might want to do that is because they don't want to pay into the system. The only people who can waive coverage, though, are people who would not be expected to ever become covered by paid family leave. And that means that if it's a full-time employee, they're not scheduled to be employed for at least 6 months. And if it's a part-time employee, they're not expected to be employed for, I think it's at least 175 days. So only temporary employments are likely to allow someone to waive coverage. And then if those extend into longer employment, at a certain point, the employee will automatically become covered, notwithstanding a waiver. And at that point, you could start making deductions for their contributions. And in fact, the law allows in that scenario to go back and make up contributions for when the employee was previously working under a waiver. Our company doesn't charge employees to contribute to paid family leave. If we want to change this, can we? Suggestion maybe January of 2024. I don't know necessarily that January of 2024 is any sort of magic date. And you may want to check even what your policy period is. I would say generally, if they're non-union employees and you don't otherwise have some specific agreement with the employees addressing the issue, you should be able to prospectively change it to start making that deduction to take their contribution. So that means theoretically you could do it much sooner than the beginning of 2024. But you might want to check with your insurance carrier to see if there's anything interesting in their documents that would pose a challenge to that. But generally the way it works is the employer pays the premium on an annual basis, and in the meantime is deducting the money from their employers to cover that cost. There's questions about New York mandated retirement plans. The current concept on that is that employers, if they don't otherwise have a retirement plan in place, will be required to offer, and in fact, by default, enroll employees in a state plan. This might well be a good topic for a future presentation. However, the state still hasn't released much information about what that state plan is going to look like. So there's not a whole lot else to discuss. And many employers at this point do offer a 401k or some other type of requirement plan, which likely means they won't be subject to that requirement. But yes, if you don't currently offer any retirement plan, stay tuned because you may soon have to enroll your employees in a state plan by default. Again, there's a question generally about the COVID-19 leave laws. I think I've pretty much addressed that. The federal laws did have expiration dates. There was a partial extension of that. The New York State COVID leave law required the paid leave depending on your size. Did not have any end date. There are a lot of other problems with the law that are all based on the fact that, again, it was passed in March 2020 and there was not that much known about what COVID was going to look like. Everybody at that time thought that basically if you got COVID, you got it once and that was it. So nobody really was too worried about how many times it was going to be used or how long it was going to last, because everybody expected it was going to be over pretty soon. But again, they didn't put an expiration date in it, so it hasn't expired. Electronic posting, is it for New York State or federal? It's a New York State law, But the New York state law seems to suggest that if you have something you're obligated to post, whether the obligation is New York or federal, then New York law requires you to provide it electronically. I suppose arguably there might be some sort of preemption issue, but I doubt it. So I think when you're sending your electronic notices or putting them on your website, that you should be including not only your New York state law issues like the New York state minimum wage and paid family leave notices, but also federal rights notices such as the FMLA, the Title VII, and other disability, ADA and age discrimination statutes. Those right notices as well. It also likely covers your workers' compensation, disability, paid family leave insurance certificates that need to be posted. And hypothetically, I think if you got a decision from a state agency that says as a condition of whatever we think you did wrong, you need to post this for some period of time in your workplace, then that may then be subject to that requirement as well. Beyond that, it's pretty open-ended, and there's not much more guidance on what else would need to be posted electronically. The WARN Act, is it correct to assume this does not include seasonal workers and seasonal businesses? Yeah, I mean, the WARN Act is a huge topic unto itself, but yes, generally speaking, if employees are brought in on a seasonal basis, then it's not expected that you need to notify them. So even if you bring in 100 employees to work a 3-month busy season, and it's pretty clear that there's a expected end date at that point in time, that's not a situation where you necessarily need to give notice. It's more the situation where employees have an ongoing expectation of employment. Here's a question that says, I thought it was 30 calendar days in a year working in New York that the employee must have paid family leave. I'm pretty sure that relates to paid sick leave. So paid sick leave is accrued based on work actually performed in New York State. The paid family leave law doesn't have an hours or days requirement other than full-time employees have to be employed for at least 6 months and part-time employees have to be employed or actually work on 175 days. The reference to the 30 calendar days, I think, relates to paid sick leave, and that is the law where there's the real specific clarification that it has to be work performed in New York State, meaning that if you have an employee who normally works in a different state but does sometimes come into New York, perform work, the time that they're in New York entitles them to accrue paid sick leave, and based on the accrual rate, once they work 30 days in New York, they would accrue a day of paid sick leave. But if that's not right and I'm misunderstanding the question, you can let me know. At this point, I think I have answered all the questions that I see. If anyone else has a question, you can type it in now before I close this out. If you are going to have a question but don't think you have time to type it in, just type something in. So I'm working on a question and I will get to that. Otherwise, thanks everyone for attending, and hopefully this gave you a lot of information, some of which you probably already know and have implemented, but I just wanted to give you a refresher and probably for everything that one person already knew, there was somebody else who either hadn't heard of it or wasn't quite sure what that meant. Of course, there are a few things that I've discussed where we don't yet know the answers, but again, hopefully this at least gives you a path of what to be looking out for and what to anticipate. Sure, there are going to be new topics to deal with as New York State and the federal government both continue to be active. New York City, of course, as well, for those of you who have employees there, continues to be a driver in increased worker protections, which necessarily means more obligations on those of you who work in HR and otherwise have responsibility for compliance in the workplace. And then as we continue to see, New York City does something that affects New York City, and New York State gets the idea that they should extend it statewide. I think we will continue to see that pattern. And then from time to time, the federal government throws something at us as well. The one last topic I didn't really discuss because I think it was a little premature, but there is out of the federal government, the FTC, the Federal Trade Commission, suggestion, proposed rule that would limit the use of non-compete agreements in some situations. So, that's something else to have on your radar, but nothing to necessarily worry about quite yet. New York State might get into the business of limiting non-compete agreements as well, I suspect. And there are plenty of other things that we probably haven't yet thought of that will eventually affect your compliance responsibilities. So I don't see any more questions coming in. Oh, I do see a clarification that the 30 days was for disability insurance. That's right. So to just address it real quick, paid family leave is an extension of disability insurance, but they do have different circumstances. So yeah, but that question did give me the chance to mention that issue with paid sick leave, that if you have employees who normally work outside of the state but come into the state, the time they spend working in New York is supposed to entitle them to accrue paid sick leave. All right, so I'll give a couple more seconds here to see if anybody has any questions. Otherwise, stay tuned and look forward to information about our future webinars. Look forward to speaking with you again about some of these topics, perhaps as more information becomes available or there are additional developments.